Meine Damen und Herren.
Ladies and gentlemen, welcome back from the coffee break. Now we come to our highlight. So we have a high-caliber panel discussion. So we look at the role of the taxpayers, focusing on the question whether taxpayers should have defense rights or whether we should see further co-determination and involvement obligations. So cooperation would be one of the key points, or taxation as something that is only done by the government. Our panel discussion is led by Martin Kreienbaum, which I definitely do not have to introduce to anyone, which is a high-caliber representative in international bodies, and our president since the 1st of 2007. He's going to be member of the OECD Tax Commission. He's bringing along his panel. Any rights left? That is the title of our panel discussion. Good morning, ladies and gentlemen. I'd like to welcome you to our panel about questions of the rights of taxpayers in joint audits and joint audit procedures. And I believe we have a 1.5 hours time to look at this part of joint audits. And it's my great pleasure to moderate this panel. So I'd like to welcome the panelists, starting with Professor Dr. Käser, the head of the tax department of Siemens AG and president of the German IFA section. Next to Mr. Käser sits Ambassador Christoph Schelling from Switzerland, head of the tax division of the Swiss Federal Department of Finance in Switzerland, and representative of Switzerland in the OECD Tax Commission, and also in the UN Tax Commission. We have someone who traveled far from here, Eugene Rossiter. He's the Chief Justice of the Tax Court of Canada. At the same time, he's also president of the International Association of Tax Judges. To my left, there's Tom Neale from the DG Taxit, the General Directorate of the European Commission taking care of taxes. He's the head of the Unit of Direct Tax Policy and Cooperation. And on my left-hand side, Mr. Henk Koller, President of the Confédération Fiscale Européenne. And Henk Koller was Senior Tax Partner at Deloitte in Amsterdam. Today, like I said, we'd like to discuss the rights of the taxpayers in joint audit procedures. And when I was asked to moderate this panel that goes for 145 minutes, I thought whether we can actually spend 1 hour and 45 about discussing questions where there's hardly any regulation international, because everyone works with their own jurisdiction and procedural law. And that applies to the many tax auditors working on the basis of the German tax law. And I thought, okay, we are going to use your expertise in this room, and that we would like to incorporate and involve the audience as well to make sure that we address all the questions that you're highly interested in. To start with, I'd like to ask the principal question that was also part of the moderation at the beginning, the question of how should a joint audit procedure be designed in the best possible manner. So that's why we don't want to really focusing on the existing laws and the different jurisdictions and the different perspectives we have here. What we rather want to do is we would like to ask ourselves how to obtain the best benefit from joint audits performed, and what is the framework that would be necessary for it. So the question is whether the taxpayer would be involved by cooperation, and what does that mean with a view to their rights. So moving away from the subordination relationship from the classic intervention administration towards a more stronger involvement of the taxpayer. Does it relate to the voluntary involvement that also has an effect on the rights of the taxpayers plus the consultants as well? Which is also my first question we'd like to deal with, and we'll start with Mr. Käser with a question. What is your idea how joint audits could be performed the most effectively for the benefit of the taxpayers, but also for the tax authorities?
Only for one reason, that's not my mother tongue. And later on I can always say I didn't mean it that way. Yeah? And when it's really bad, I'll say it was just locker room talk. You know? But maybe we're not coming to that point. The question is a difficult one, even so it's a very abstract and it appears to be simple at a first glance. For us being taxpayers, the decisive question, the decisive goal is in each audit, we only want to pay tax according to the law, and we only want to pay tax once. And this is the aspect which, with regard to joint audits, is the principle, the most important one. A joint audit for me gives the chance to avoid double taxation at a very early stage. You all know that the mutual agreement procedures, dispute resolution mechanisms around the globe aren't such that they ensure that there is a relief from double taxation. We have very little double taxation treaties where there is a mandatory dispute resolution built in. For example, the one with the United States, and I think the one with Canada as well has a mandatory dispute resolution. Without a mandatory dispute resolution mechanism, it's only a mutual agreement procedure, and at the end, both fiscal authorities can just walk away and say, we discussed the matter, but we think our position is correct, and the other party will say, we think the same for our position. And the one who is paying the bill for that disagreement is at the end, that's us, that's the taxpayer. And we have all followed what's going on with the BEPS project for the last couple of years, and I'm absolutely concerned and that at the end of BEPS, we will have way more double taxation because the PE concept is softening, it's weakening, so there will be more PEs. And every permanent establishment normally gives rise to disputes, to different profit allocations. Transfer pricing is moving away from, and you will certainly disagree with that, Martin, is moving away from what is known as the arm's length principle into a more arm's length principle based on economic grounds, not so much with the contractual relationships, but more with a view on significant people function, economic substance. And I'm not saying that this is a wrong trend, but it's certainly something which will increase uncertainty, because every time you have to apply an economic analysis, and I'm a lawyer, I can say that, it's not precise. A law is precise sometimes, most of the times it's not, but economic analysis, valuations, they are certainly not precise. So there will be many different views and perspective of an economic situation. So with that, we'll have more and more disputes. But we have uncertainty in the meaning of how to resolve them. And if you look around the globe, in Europe, for example, we have a mandatory mechanism. We have, with many treaties, we have mandatory mechanisms. But where we are really expecting that there will be double taxation with developing emerging countries, or with countries that honestly aren't developing anymore, but we still used to call them developing countries, China and India, we will have a lot of dispute cases. And they don't agree, at least on a short term, to implement mandatory dispute resolution mechanisms. Yeah, I know there are not many joint audits with those countries, but a joint audit is, for me, the chance for good taxpayers, transparent taxpayers, to have an open discussion on both sides with two fiscal authorities and bring those at one table, explain the economic setup, explain the situation, and in such a scenario, I'm convinced that at the end, there will be no double taxation. Yeah? Because if you have an open, honest, transparent discussion with fiscal authorities who see that at the end there's only one cake and you can only eat it once, yeah? They will understand that they have to come to an agreement on an economic situation, on an economic split, on transfer pricing. So for those matters, I really see a good chance that joint audits will help us in avoiding double taxation, and I see a good chance that joint audits will help both sides, the taxpayers and the administrations, to achieve something that we always have been, not always, but for many years have been striving for, and this is enhanced cooperation and enhanced relationship between the taxpayer and the fisc. There will always be subordination. There's no doubt about that. You colleagues here in the audience working for fiscal authorities, you are representing the government, and there is a subordination between, if you're from the US and Canada and some Anglo-Saxon countries, this concept of subordination doesn't fly that well, but in the European context, there is the concept of subordination between government and the taxpayer, and it's quite clear. On the other hand, there are many proven cases with Netherlands, with Singapore, with the UK, sometimes even in Germany, I'm not saying which state, where you can overcome that subordination to some extent, and you can have a very good relationship. And I'm convinced that with joint audits we can improve that status, we can improve the setup, and can then come at some point in time to a better common understanding. So this is what my expectation for joint audits would be. I know that the topic of our discussion is any left's right or right's left. These days you can get confused about that. But I'm sure we will discuss what we expect in terms of our participation at a later stage. I want to stop at that point in time so that I don't absorb too much with speaking only.
Vielen Dank, Herr Käser. Ich glaube schon auch, dass wir den Joint Audit.
Yes, Mr. Käser, of course. We have to see joint audits with the arbitration procedures and mutual agreements, and also have a view from Switzerland, if you would like to comment of how you see these joint audit procedures. And how do you assess the benefit and how it should be legally designed so that taxpayers, but also the administration, would get the best benefit from it? Yes, thank you very much, ladies and gentlemen. We in Switzerland, we're always trying to have a cooperative approach with the taxpayers. And that's the basic and the underlying approach we are using in Switzerland. And that will also relate to the tax audit as well. Traditionally, every individual state is using their own tax audit, and then there will be a bottom result, and then, of course, you might also coordinate that by mutual agreement. The joint audit and the joint tax audit is supposed to give the means that things are being dealt with together, and like Mr. Käser said, this could lie within the interest of the taxpayer and the entrepreneur. We also see a regulatory environment that we have to face, so where these joint audits between states are being permitted. Seeing this from the perspective from the country that I come from, then I can say currently there is no such thing like a clear legal principle that would allow us to do that, having a joint audit. And there's also the instrument of simultaneous tax audit, and based on the treaty of mutual agreement on tax issues. So if two countries want to do that, they can make this agreement. Switzerland has done this already and has signed it, and it has ratified it, and so that's why it can be involved. But of course, we always take a closer look at that for the future, and I find this is a highly interesting instrument. And I think the regulatory principles have to be checked again, and we have to think of what is going to be applicable and what is the result of a joint audit. what does that mean legally? And it's not, a disposition by the state, because mostly these are two states that have identified and determined something. And then it goes back to the individual states of the both parties involved. There might also be 3 states being involved theoretically in such a joint audit, and that follows again their own procedural principles applicable in that particular country. And of course you have to see this, and that is a preliminary state. There will be an earlier stage, and the tax audit, when it comes to the assessment or when the tax assessment is being revised. And also the other points Mr. Käser mentioned in MAP, and said there will be a mutual agreement procedure. Thank you very much. We will talk about this question more intensively of how such an international legal framework should look like once you have an international framework or agreement like that. How should that look like concretely? Now, let's hear the perspective of a judge to see what could be the benefit of joint audits. And the judge, of course, is involved into the the solution of the disputes, and in joint audits it's like a pre-phase that might lead to avoid disputes. So to what extent this can be done, and to what extent this could be the case, that would be the discussion we should discuss. And would there be a binding effect, for example? But I would like to ask Mr. Rossiter of how he would assess the benefit of joint audits.
In that one statement there, and I'll have to try to answer them, not them all, but just from a general point of view, let me start by saying that Canada has very limited experience with respect to joint audits. Our court is a substantive court, a trial court, and we don't involve at any level of that. They come before us when there's a dispute and assessment, but I made my inquiries, and there's only been one joint audit conducted by Canada and the Canada Revenue Agency. That's with the United States. But let me start by setting the table here a little bit. As I understand it in the European community, I'm told that auditors are looked upon friendly and somewhat welcomed. That's what I'm told. Now, I could be wrong here. I don't know. But in Canada, the opposite is true. In Canada, an auditor is most unwelcome. I can tell you that when an auditor comes to the door in Canada, the taxpayer says there's going to be one of 2 results here. One result is it's going to cost me more money to satisfy this auditor, or number 2, I'm going to pay more tax. Either way, there's money going out the door. And no taxpayer wants more money going out the door. In fact, I sit here and I say to myself, people are going to pay their fair share. I don't know one single person I've ever met, not one single entity I've ever seen, that wants to pay tax, unless their name is Warren Buffett. It simply doesn't happen. Nobody wants to pay tax. It's just a question of how much you'll pay and when you'll pay it. So with that background, that's how the Canadian people think. That's how the U.S. people think. But when you're talking about joint audits, I think the joint audits, in the large scheme of things, are in everybody's best interest. You have 2 fiscal entities that have an issue with one taxpayer, only one pocket to take money out of. So there has to be a consensus here. And in order for a joint audit to be successful, the key is the taxpayer. It's not going to be successful unless the taxpayer is on board with it. It's not going to be successful unless the taxpayer is cooperative in the approach. The taxpayer is in the driver's seat. The 2 fiscal entities want the taxpayer on side. The taxpayer is the one who has the leverage right from the beginning. If the taxpayer uses that leverage and doesn't participate in the joint audit, then you're not going to have a joint audit because it's a cooperative approach. Now, there are many advantages to the joint audit. I don't have to enumerate those. Everybody knows what those are. But having said the foregoing, the position of the taxpayer is really no different in a joint audit than it is in a regular audit. He has the same privileges, powers, entitlements. All the rights and privileges are still available to the taxpayer throughout. The problem with a joint audit right from the beginning is the level of comfort for the taxpayer and the level of comfort for the taxpayer throughout. And we see this on a regular basis in court, in litigation, and where the taxpayer is pitted against the Canada Revenue Agency and the level of discomfort, the level of discord that there is. And that's why they're in court. That's why they're looking for a dispute resolution mechanism. They come to our court, is because the level of comfort, the level of satisfaction, the level of trust, the level of faith is not there. So you can talk about joint audits all you want till the dogs come home, but it's not going to fly unless the taxpayer's on side. And you as tax auditors, I think you really realize that, and that's why you have such a cooperative and, I'm told, friendly approach in Europe. Please transport that to Canada. It'd be most helpful. Thank you.
Ja, vielen Dank. Also die rechtliche Position des Steuerzahlers dieselbe.
Well, thank you very much. The legal position of the taxpayer is the same in our other tax audits. That's something that we have to discuss. It seems that everybody is in favor of a cooperative approach, and that what that means we'll see in a minute. And that might be described above from the point of view of the European Commission. Is there a need in Europe to have a harmonized legal framework for the joint audits and to promote them? I would like to ask Tom Neale about that.
Everybody. I think the first thing I should emphasise is that from the Commission side, we're neither a taxpayer nor a tax administration. But what we do is we have the power to propose legislation when we think it will assist or improve the internal market. And I think we've already touched upon one area where we have a proposal on the table at the moment, which concerns dispute resolution. Now that's, if you like, at the end of the process. So the Commission has looked at the issues and has felt, well, we need to have a dispute resolution process at an EU level, in the sense that we're proposing something to all the member states to resolve double taxation. And the idea of this is that if you've reached the stage where there is double taxation, we are suggesting that there should be a duty on tax administrations to remove this. Now, clearly, before you arrive at a dispute, you want to try and ensure that the single market is working efficiently. And that's where we looked at the possibilities of tax audits. Now here, the one point I should stress is that, of course, anything that we propose would be for the EU. So we're looking at a subset. We're not able to stretch out and look at the wider world. So we would be proposing something for within the EU. Now, at the moment, we already have a legislative framework that has been agreed by the member states for administrative cooperation. Now here, I'm sure you'll be familiar with what can and what can't be done. Now this is about exchange of information between tax administrations, but there are very powerful tools there that do operate at the moment. And if you stretch those, then clearly some element of joint audits can be carried out. But of course here you're into an area, it's a grey area. Is it a joint audit or is it a simultaneous audit? What can actually be done under the directive that's there? The directive has been proposed, it's been agreed by the member states, and they've implemented it. But it leaves the actual way in which an audit is carried out at the moment, it stays with the member state. So you all have different ways of carrying out audits. Some countries may be able to have a proper joint audit in the sense that they could have members of another administration in a joint audit team, whereas others will not. And this is an area where, at the moment, the Commission is actively looking and listening to people saying, well, is it a good thing to have a joint audit? And if it is a good thing, is it possible at the moment? If it's not possible at the moment, would a legislative instrument assist in this? And that's where, as Martin said, should there be a legal instrument is one of the areas that we're looking at. Because I think one of the things that we take a sort of long-term view, looking at the development of the internal market. More and more companies operate cross-border. The company that operates in just one country is now becoming relatively rare. As soon as you move cross-border, you will, if you like, be into that area where joint audits might be helpful. So that's the area that we're concentrating on. Of course, we also have on the table a proposal for the common consolidated tax base. Now there, you're in a different area altogether, because clearly if you have one tax base, and when you get to the consolidation stage, quite frankly, I can't see how it would work if you insisted on having individual national audit practices and always individual national audits. So longer term, it's inevitable that if that proposal goes through, there will be moves to ensure that joint audits are legally permissible. But for the moment, we're in the current situation. We don't have a common tax base, but we are considering from the EU perspective, would it be helpful? And that's why this sort of event for us is very interesting, to hear about the experiences that certain other countries have had, what they can do, what they can't do, what the advantages are for the taxpayer, what the advantages are for the tax administrations, because it is key that both parties see that there are advantages. I think I'll call it a day on that one.
Vielen Dank.
Mr. Koller, I would like to ask you as well, from the point of view of an advisor, where do you see the major advantages for joint audits? What do you think should exist in terms of a legal framework under international law, and how could that be done? I promised to speak German, but now that everybody is speaking English, I would prefer to speak English so that we don't get too confused.
Yes, at first sight, nobody can be against it, I would say. The idea seems very good, it seems to be efficient, and it would easily result in a win-win-win situation, as Eugene called it earlier. Both tax authorities could avoid uncertainty and unclarity, and even the taxpayer should win from it, because ideally, as what was said by Mr. Kaeser before, it is the outcome is avoiding any misunderstanding, and moreover avoiding double taxation. And if that is the outcome, it would be wonderful, and who would be against it, as said. However, giving it a bit more thought is that until now, unless I see it wrong, and I hope you will correct me in that case from your side in the audience, that is the desired outcome, and sometimes may be the outcome if all parties are willing to get there and able to get there, but it is in no way guaranteed. Still, the legal framework does not oblige tax authorities to come to that result, certainly not at this stage. Even if you have a dispute resolution mechanism afterwards, I have not understood that the joint audit would automatically prevent that. So asking whether we need a legal framework to ensure that, yes, I would be thinking that we do need that, because otherwise we are relying on cooperation between three parties who in good faith do their best, but you don't know where you end up. For example, in the case we have seen yesterday, where there is, if there would be a joint audit between China and Germany on this particular case, the Chinese say, and they mean they are right, that the Chinese company does not report enough profit, whereas the German auditors say too much profit is shifted to China and the royalties should be higher. I don't see how in an audit process this could be solved. There are different viewpoints, and ideally I would say this should also be solved in a joint audit, because if not, what is the difference between a joint audit and a simultaneous audit?
Vielen Dank. Ich will für die weitere Diskussion.
For the continuing discussion, where we're going to be talking about the rights of the taxpayer, I would like to come back to a point that Mr. Rossiter made, which said very clearly the rights of the taxpayer are the same as in a normal audit procedure. And that begs the question, how do you differentiate a joint audit from the question of a simultaneous audit? Is the only difference that the auditor from another country comes to Germany and is allowed to be present here, which gives rise to legal issues as well? Or are there other questions beyond that? The cooperative element, does that give rise to other legal issues in relation to protection of rights, or whether the taxpayer, if he collaborates voluntarily, whether there might be a certain binding effect of the findings? And I would like to ask Christoph Schelling, first of all, how that would work. First of all, I have to say that this type of joint audits, certainly in Switzerland, would be uncharted territory if we started to do that. Up until now, we've carried out these audits unilaterally, and then depending, we would have a mutual agreement procedure and have an exchange with the other country, and the results are made available to both parties. And that is defined in convention law. If one could take a shortcut here also, that would be in the interest of the taxpayer. This would be a very interesting approach. To further pursue it, I think will be possible in the years to come, because we will get more legal basis for this. I already mentioned the agreement between the OECD and the European Council, and that will be binding for the member states, so that at least simultaneous audits are provided for. And that means that a tax auditor in one country can participate in an audit of another country if he's competent. And the result of this audit would be a result subject to the country in which the law of the country in which the audit is carried out. And what is the benefit of the participation of an auditor from a different country? The benefit is that this other country would have the same information at the same time. And if he wants to make adjustments or corrections according to his tax assessment or appraisal, he can introduce that. And in future, we will have a legal basis that is relatively new here. And for my country, it is new that this is actually possible at all. And in future, we will be able to see whether this path is successful or promising. And then we might be able to approach the question which Martin Kreienbaum mentioned, i.e. what is the difference between a simultaneous audit and a joint audit. I'm not quite sure what the difference is. And that would have to be decided from case to case. A finding of an audit team is not automatically lead to law or decrees in the other country. That would have to be transformed or translated into the law of the other respective countries so that it becomes obligatory or binding. And I think all countries see it like this. And a multi-law approach would be applicable here. So I think we've got an interesting new legal area in front of us which could preoccupy us. But I don't think it should be a means in itself. In order to go down this path, it has to be useful. It has to be useful for the tax authorities involved, and it has to be useful for the taxpayer. Because that is the third party, and everybody has to be able to do it jointly in order to get results that you can back. I think the situation is very exciting. I think we should start with what we have. At the moment, we've got a simultaneous audit or the possibility of that. And so let's embark on the journey and see how that can be expanded and what else is available. Mr. Käser, do you agree, or do you think there might be a bigger added value from the point of view of a company in view of the binding effect of a finding of a joint audit? Possibly limited to the finding of facts, maybe expanded to legal conclusions. How do you see that from the corporate point of view?
Just said with regard to the example with China. I would never expect that with China you could convince the Chinese tax auditors that their approach is wrong, that location-specific advantages shouldn't influence transfer pricing because that's their basic position, and that's not the position the rest of the world, at least not most of the rest of the world, is sharing. So that will be a difficult one. But even in that scenario, it will have an advantage. Yeah? And that's then bridging to your question. And this advantage is that when we are discussing with our auditors in the Western world, be it Germany or other countries, sometimes the field auditors, they just say, that's what you pretend. Yeah? I mean, that's what you say you will run into problems if you adjust your pricing in China. But in reality, you are so profitable that will be no issue. There will be still a lot of profit left there. If those two auditors would sit together and the Chinese guy would tell his colleague in the face, you know what, and they're only at 21, yeah, and would explain the position to the Western, yeah, industrialized countries' auditors, then the auditor would understand that we are in a catch-22 or catch. I never can remember this number. In somewhere in between a hard rock and a no. What was? Yeah, I should switch to German again. You see, that's what I meant when I said
rock and a hard place.
A rock and a hard place. That's it, right? Thanks for that. So this gives me the opportunity later on to say I didn't mean it that way. No, but we are catch in between, yeah, and we will never be able with these countries to solve this situation. But it would improve the understanding, at least on our side. And this is an advantage. This is an advantage even in such a scenario. Coming back to what we expect in terms of the outcome, I would differentiate between at least two base cases. The one would be a case where it's a treaty-related question. Is there a permanent establishment or is there no permanent establishment? Or transfer pricing. You know, there might be others, but those are two base cases. And then questions where a joint audit helps one auditor, one country, to find out facts which are only required for the application of local law. Deductibility of interest expense or something like that, yeah? Which is not a treaty question. And I think this is an important differentiation because at the end, the two fiscs are somewhat aligned in their interest. Yeah? And I've once given that example, nobody liked it, that in a joint audit, the taxpayer is the rabbit and multiple dogs team up to hunt the same rabbit. In a way, I still think this example isn't that incorrect. Yeah, because if you think in a subordination case, there are two governments and they team up, yeah, and they think alike. They are auditors. They think alike. Yeah, so they want to achieve an extra result for the government, and I understand that. Yeah, and you rightfully said there is no taxpayer that likes to pay tax. In public, I would never sign up to that. But if we would have a private conversation, I would say, yeah, it's I can share that idea. So. Yeah, two different interests, and over time in the joint audit scenario, even so you start maybe with the limitations given by treaties for the exchange of information and things, so some at least basic legal framework. Over time, yeah, this shared interest on the side of the auditors will give them even more teaming up. Yeah, so they understand each other, they have the same interest, and over time they might not even live up to certain limitations. In practice, information will be shared much faster and not respecting certain legal limitations. That's just the nature of the game, and this is a risk, and that's why I think we really have to differentiate. And I'm not contradicting myself in treaty situations, transfer pricing, permanent establishments. I would even go for a joint audit with China, with other countries. In the wider sense, so having a full-blown joint audit, I would only want to see that with countries where I trust that in the end they are not going to hunt us down, but where we have a solid relationship with the fisc, and with most, not all, most of the European countries, that is the case. Some it's not the case, and I'm not saying which ones. Yeah, but there you can have a full-blown joint audit, and you just said simultaneous audit might be maybe a more desirable approach that boils down to defining what really is a simultaneous audit. If it's two FIScs not talking to each other and doing their audit and at the end sharing the results, for me that would be not a big game changer. I think that a joint audit gives us advantages in the civilized world. It's politically incorrect. In the Western world, it's even more politically incorrect. There you go, but it's English, so I can change my mind later on. It gives us just the advantage that we can be faster. And can build even more trusted relationships.
Ich habe schon den Eindruck, wir sind alle auch so ein bisschen verhaftet in den Erfahrungen.
I think we've all made our experiences that we all made in the respective procedures or also in collaboration with foreign tax authorities. Nonetheless, I would like to ask the question whether by improving trust relationships with other tax authorities and cooperation, we could achieve more also in terms of hard law. And I would like to come back to a binding effect, which might be obtained at the beginning of a procedure with the cooperation of the taxpayer. Mr. Koller, would that be an approach which would be conceivable for the taxpayer in order to have a differentiation between the act of intervention by a country and what you can achieve more if you pursue a cooperative and collaborative approach, whether one could tell the taxpayer, I expect more collaboration, but on the other hand, there is a law for both countries involved relating to the binding effect of the findings made.
Yes, that would be great. However, I come back to the point that you can do this two ways. Either by legislation and get taxpayer rights and taxpayer obligations clear, get the obligations for the tax authorities clear to avoid double taxation and what have you. Or you stay at the cooperative level with good intentions and in many cases even the desired results, but there will always be cases in which there is not the desired result. And then, of course, you may already have had one benefit, as Mr. Käser explained, that there is more understanding, that there is more empathy in the process thereafter maybe, but you have not gotten to the result which you would expect if you enthusiastically talk about joint audits, that there will be an outcome that is from the outset to be avoiding disputes. So indeed, if the outcome would be guaranteed that there will be no double taxation, and ideally it would also be binding for the future, that the next year you will not have an audit on the same topic again with a different result. If this is okay, you can continue as long as the fact pattern doesn't change. Of course, that would be very helpful, but it would even be more helpful if it is in the laws and regulations so that the taxpayer can rely on it. Because if I may say so, over the past few years, we've seen a lot of discussion about multinational corporations not paying their fair share of tax, if somebody knows what that is. And there's been a lot of actions, as you know, BEPS, EU, etc., all focusing on more rights or better instruments for tax authorities, whereby the position of the taxpayers has been forgotten, maybe not forgotten, but not being paid a lot of attention to. Fortunately, with two exceptions, for which we are very grateful, that the EU has come up with this draft directive for dispute resolution, which is very helpful, and I really hope it gets through. And the long-awaited taxpayer code that will also clarify a number of rights taxpayers have. Because indeed, as we said before, as long as the relationship is good and we are friendly and there are no disputes, we can do without the rules. But you can also do without a marriage contract until you divorce. And the rules should not be there to look at all the time, but they should be there to rely on once not so clear. So I hope that answers your question.
Ja, ist noch ein wichtiger Punkt mit in die Diskussion eingebracht worden, nämlich die Frage.
Well, an important point, the binding effect for the future, that's good point. If an authority only looks at the perspective of one case and agrees that a certain fact will be dealt with in a certain manner, this will also have an effect for the future. Will the same facts, can this be realized in the next years? Will they have to be treated the same in the coming year? And that would be done on the basis of national law. And accordingly, the question comes up whether this could be standardized and in order to create, and whether that would require a legal framework. The point that I'm aiming at was the question of the binding effect of these concrete determinations for the further procedure in their own country. So that means administration and joint audit, and they feel to comply with it. And what does that do with the legal position of the taxpayer? So I hope to get the objection from Mr. Rossiter, who might say that these rights, with the pursuance of the right of the taxpayers, that these would be limited. Mr. Rossiter, what about the binding effect of the actual determination and possibly also the legal conclusions, if you had to differentiate between these two elements?
Well, let me go back. First of all, the difference between the joint audit and the simultaneous audit, to me, is in the joint audit, it's a tripartite arrangement. The simultaneous audits, it's not a tripartite arrangement. There are still three involved, but they are involved separately. But in the tripartite arrangement, you want to come to an understanding at the front end. The OECD report and participation guide in 2010 set out some guidelines and best practices for joint audits. And I think the bottom line is that the more clarity there is at the beginning, the better it is for everyone, both fiscal states and the taxpayer. And you need procedures, you need protocols, you need practices, you need dispute resolution mechanisms right at the front end if you're going to have the taxpayer to buy in. Now, I'm a judge. I don't advise taxpayers, but I'll tell you, in the back room, the taxpayer came to me and said to me, should I go into this joint audit? And I'd say, not unless you got them right by the throat. Because you are the one that's in jeopardy here, not the fiscs. It's just like a colleague said here, you're the rabbit. Now, you're maybe not the rabbit in Europe, but in Canada and the United States, you're the rabbit. And you shouldn't approach it any other way. So you have to have clarity. You have to have practice and procedures. Let me give you the example what they did in the United States and Canada, and the one audit that they did there. This was a multinational corporation which was on the permanent audit list in the United States. In other words, they were audited every single year, come what may. And the Canadian and the United States got together and discussed a joint audit. Now, you have to understand the difference relationship between Canada and the United States. Canada is the mouse, and the United States is the elephant. The United States is 335 million people. Canada is 35 million people. The United States is the parent corporations. Canada has the subsidiary corporations. So there's very much a bended knee there to a certain extent. But right from the beginning, I'm advised that what they did was they sat down, and the biggest part of the audit, I'm told, was the detailed flow chart that they prepared from the beginning on how to resolve disputes throughout the audit. And the taxpayer was at the table right from the beginning with their advisor. Everybody signed on to the processes right from the beginning. And those included even to the situations where if one fisc wanted to withdraw from the audit, how could they withdraw from the audit? What were going to be the tiebreaker rules if there was a dispute? What about thresholds? Because in the United States, the thresholds that IRS would pursue were significantly higher than the thresholds that Canada would pursue. So there had to be understanding of those and how those were going to be resolved. And this is how they started off the audit. So the big work was all done before they even went in and exchanged the information and the facts and went through the processes and decided what the result was going to be. At the end of the day, in that audit, they took out 10 years of separate audits. And they came to an agreement as how they would proceed in the future on similar facts. So, to use a phrase, it was a win-win-win for everybody. It wasn't a win-win-lose. And unless the taxpayer sees the significant probability of a win, they're not going to go in. And I think you have to recognize that at the front end. Now, as far as having a legalized practice, procedure, and protocol and statute, whatever, that's years away. I think what will happen here is over the years, Joint audits will catch on. There'll be more joint audits taken. There'll be more countries involved. There'll be more practice procedures developed. And eventually, a standard practice and procedures will emanate from the various countries that have involved, and then we might see some legislation. But that's, I think, years away. Thank you, Martin.
Vielen Dank. Weitere Kommentare vielleicht?
Thank you very much. Do you have a response, Tom Neale?
Perhaps I would draw on, I mean, the basic question is hard law versus soft law. Now, at the European level, we do have experience with soft law in the sense that harmful tax competition has been managed at the EU level between the EU member states on the basis of soft law, political agreement. But at some point, you're going to need to move to hard law. Now, I put tax competition to one side, but when we talk about the audit side, it really is going to be a question of, it's all very well going along with a nice agreement. Perhaps for each joint audit you have a particular agreement, but that's very time consuming. And there will always be an issue if you have an agreement between the tax administrations. What happens when that breaks down? And I think that's what we heard, that it needs to be established beforehand. And then the question will become, is it sensible to do this for individual audits, or is it more sensible to arrive at a pan-European approach, to arrive at a legislative approach for how one might carry out joint audits? And the problem there is that it's very, very difficult to get agreement. I think you mentioned the taxpayer code, which the Commission is about to publish. Now, this code took us a long time to prepare. We had a public consultation, then we had meetings with member states. But although it's called a taxpayer code, essentially it's the tax administrations who have prepared it. And what this code is doing is it's laying out what the taxpayer can expect and what the tax administration can expect, what they can expect from each other, what their rights are, what their obligations are. Now, this has taken a long time, and it's advisory. It will have a very large disclaimer on the front page because the member states would not have been able to sign up to a taxpayer code if it had been legislative. So we have an advisory code. So we've taken a little step towards having taxpayer rights protected in a common way across the EU. Now we talk about joint audits and we say, should we have a process, a legal procedure? Well, we begin to make a few steps. We have the administrative cooperation, but it's quite a big step to get to that final goal. But I think it is important that we understand whether it would be worth going there. Because if we decide it would be worth going there, then we put in places the steps to get there. We make sure that if we do carry out a joint audit, we ensure at the beginning that we have the right terms drawn up between the parties. And just to pick up on one point, the issue of tax administrations versus the taxpayers, one thing I would say is that you might say the tax administrations have a big advantage, but the companies also have that advantage, that the companies, when you're talking about a parent and a subsidiary or a company and its PE, the taxpayer knows everything that he does and knows how the business works, every detail. The tax administrations don't. The tax administrations start off having to ask. So I don't think it's quite so unbalanced that the tax administrations have all the advantages. The taxpayer is there as well. And that's why when you come to start a joint audit, you do need to bring them in, but don't start by saying one party has an advantage over the other to start from. I think you start and you need to arrive at a common position. But as I say, hard law, soft law, from the Commission side, whatever is best for the EU, but we have to wait to see what people say to us.
Ja, vielen Dank.
Thank you very much. We should discuss also what we actually needed in order to make this a big step. Or what is our proposed outcome? What would be the concrete regulations in the procedural law with a view to binding effect on material rights? And where at the end, where we'd like to end up having, in order to have a win-win situation for everyone involved, for the administration and the taxpayer, and also for the consultant, right? And at this point, I'd like to open this discussion for the audience. If you have any questions, When you have any ideas following the discussion, when it comes to the involvement, inclusion of the taxpayer into joint audits, any questions we might have missed, this would be the great opportunity to ask questions. Yeah, Mr. Schmidt. Schmidt, Bavarian Financial Ministry. Looking at the discussion, my impression is that it's strongly related to terminology. So we talked about the joint audit versus simultaneous audit. The question is, how far does the simultaneous audit and where does the joint audit start, definition-wise? Does that mean you just listen to the taxpayer, or may the auditor from the other country may also ask the taxpayer questions, which is the case based on European law? So if both countries have implemented that. But I think it also means that joint audit means that you also find a common legal result, and this will go far. So first of all, you have to find the facts that are underlying, and that's why I think it would be quite helpful if this would also render benefit for the taxpayer. Both sides, Mr. Käser said that if both parts would approach from the same facts, then it's always better, even if the legal positions might be divergent about these facts. So coming to the joint legal position, I think that would be a big step, but that is also part of the embedded dispute resolution method. And so we have to see step by step how this will develop in the practical terms. Thank you very much. Does anyone want to respond directly, Mr. Käser?
To some of the remarks earlier, totally in line with Eckhard Schmidt there. You said that there is no advantage on the side of the fiscal administrations of the auditors. What I said earlier is that their interest is aligned. I didn't say that they team up in regard to advantages. And I don't assume that many, or if at all one country, which is really difficult, is represented here in this audience. But there are fiscal administrations out there which at least intensively use the one advantage they have, and that is that they can assess. Yeah? And they can assess whatever they want to, because in some countries, law might be a starting point for discussion, but it's not in any way as binding as it is in Europe and the countries that are represented most likely here. What I said earlier is that in a joint audit, we are always willing to participate, and we had good experiences with joint audits, but only with joint audits between countries where there is a trusted relationship and where the law is not only the starting point. Because in every other scenario, I would have the feeling we would be totally lost. And the other point is, we were earlier discussing how binding should the results be. We would never sign up to audit where we would forgive our right to litigate at the end. Yeah? Because we would never accept a situation where we would be in a weaker position than in a normal, traditional audit. And I would see absolutely no reason for that. And that might have been a little bit of a misunderstanding. We should differentiate between the results being binding for the two fiscal administrations, yeah? So that if certain facts had been discussed, all questions had been raised, and the facts present themselves as they are, I mean, they should be binding then for the two administrations. Yeah? But as you all know, in the traditional audit, sometimes there's disagreement about the facts. So that even the two fiscs might think that those are the facts. The taxpayer can still disagree, and in that case, he can litigate. Yeah. And we would never give up that route, never ever. And I'm absolutely convinced that in at least the European legal systems, this is the fundament of of what we have: legislation, administration, and jurisdiction. Yeah. So this is our fundamental right. We would never give that up. So we would never, at the beginning, accept that any outcome would be binding. Doesn't mean that at the end of our audit, all parties could agree and say, you know what, this is the facts how we present it. We think this is the legal outcome of it. The authorities would say, or vice versa, we see it the same way, and we would say, okay, we all agree on it, so we forgive our right to litigate, because then there is no reason to litigate. Yeah, if there's total agreement, that's two things we need to differentiate.
Mhm. Wenn ich da gleich zurückfragen darf.
If I may ask, would that be a benefit, a progress from the industry, if there would be a binding effect with a view to the agreement on the concrete facts without having to give up rights with regard to the legal appreciation?
The two fiscs might not be willing to agree on facts, because you see, if we disagree, about the facts, then apparently we think we are right. So it's not unlikely that if there are two more parties, one you need to disagree, because if you are all alone, I never disagree with myself. Mm-hmm. And the days where I disagree with myself, I have serious troubles. So you need at least one party. But if you have two parties, one might be in agreement with yourself. So I don't even think that at the end there might be an obligation for those two to agree on the facts, because it would be a schizophrenic situation in a way, So we might disagree, they might agree. So I'm not totally convinced that this is a necessary outcome. I'm not totally convinced. I'm not absolutely sure about it, but I'm not totally convinced.
I'm a little bit at a loss as to why anybody would think that taxpayer would agree to be bound by the result. I mean, what you're entering into here is you're entering into an audit by mutual agreement. It's a tripartite negotiation. It's a tripartite sharing of information, of understanding, of working together to come into a common solution that everybody's comfortable with. There's going to be give and take throughout the piece. If there's not give and take, you're going to come to a result which somebody's not going to be happy with, and they'll be able to litigate it. I cannot imagine a taxpayer giving up the right to litigate on the front end. I just can't imagine it. It won't happen. Now, there's a unique situation between Canada and the United States, which I'll share with you, which you may not be aware of, but there is a certain attraction to Canadians going to a joint audit with the United States. Because in the United States Fiscal Authority, they can settle strictly on the basis of money. Show me the money. That's what they deal with. In Canada, the fiscal authority there can only settle on the points of principle. You have to have a principle-based settlement. Well, I tell them all the time, there's no principle more important in the world than money. They don't seem to get that. But if you're dealing with the United States, they're the bigger elephant, you're the little mouse, you can always kind of sift over and make a deal, show me the money. That's how they operate there. Anyway, I digress. I go back and say the taxpayer is simply not going to agree to be bound on the front end without knowing what the result's going to be. That's just not going to happen. I agree with my colleague here.
Ja, das bringt mich auch noch zu der Frage, die wir vielleicht später noch diskutieren. Die Frage, hat der Steuerpflichtige einen Anspruch auf Durchführung?
Does the taxpayer have a right to come to an agreement? Can he block a joint audit intended by two different tax authorities? Mr. Schmidt from Baden-Württemberg. Thank you very much. I think we have to go back to the character of an external audit. We're talking about research and determining of facts. The facts are the center. Every country that participates in a joint audit has its own legal order, which is applicable for the respective auditor that applies to material law and procedural law. So it's a very complicated thing. But if you have a real joint audit, every auditor can audit according to his legal order. And if there's a joint audit with a taxpayer, either possibly here or possibly in a different country, possibly also simultaneously, you can find and investigate facts. If every country audited for itself would be far more difficult to obtain, or maybe not be able to obtain at all. In a joint audit, one can have certain disagreements about facts, but the probability, because of the way it's run, that one has investigated facts jointly, then it's likely that one comes to agreement, rather more probable than if you have a separate audit. If you have differences of opinion in a separate audit, basically you only have a mutual agreement procedure or the arbitration procedure. If the object of these procedures are the definition of facts, I think there's a great possibility or probability that this would be preempted in a joint audit, i.e. we have an acceleration and a greater probability or possibility of agreement in the event of contentious issues. I know from Baden-Württemberg, from my area, that the big companies really welcome that, especially the taxpayer. You talked about subordination, i.e. the subordinated party in Germany who is really dependent on the who's subordinated to the tax authorities, in fact, in favor of this procedure. And the tax authorities have an advantage as well. The reality is the following, that the company that we ordered says that we can follow your conclusion, but the foreign auditor would like something different. So in very few cases, the German company and the German tax authority, we would be represented by the BMF in a mutual agreement procedure to clarify the situation. And a part of that can be avoided in a direct conversation. Maybe if there is a dispute, even if it's a dispute, this can be dissolved in a joint audit. So we are making the processes faster and leaner. And the taxpayer in the past isn't bothered by tax auditors so much, and we get our money more quickly. So this is the point, the clarification of facts, the solution of disputes at an early stage and with mutual agreement. And let me just say something about the EU Commission, and for that we don't need any new rules. We don't need rules that would apply in this case that I just described, which would improve the position of the taxpayer. The taxpayer is already in that position, and a joint audit is an improvement compared to present procedures because he has a parent company here and other subsidiaries in other countries. And I'm talking about a German automobile manufacturer who has 1,011 subsidiaries in other countries. So if you can solve problems bilaterally or trilaterally, I think that would be in the interest of everybody. Thank you, Professor Schmidt. I think this was an important contribution. I would like to add that in our preliminary talks, where we discussed this discussion, we thought that we would let our imagination run free and think about how could this be made most efficiently to the satisfaction of all those involved, and that we don't look too much on the existing legal frameworks, that we want to look into the future a little bit. But nonetheless, it's very important what you said. Of course, we are bound by our national legal orders, and the question that we're asking ourselves here is there any cause to change that? Would one have a benefit for the taxpayer or the tax authorities if we made changes? Let me ask the audience again. Does anybody want to ask something?
The European Commission improves the automatic exchange of information. But if we talk about joint tax audits, I do not hear anything from the Commission, or not very deeply. And I'm not sure if all people in the German tax authority believe that we should not have any more European law about joint tax audits. I think there should be a common base about Europe, and not only a base in every country. So we have procedure law in 26 countries. There should be one European law, or one imagine of a European Commission. So can you tell me, Tom Keen, is there any improve of joint tax audits from the point of the European Commission?
Yeah, you can. Yeah.
I mean, at the moment, it is considered to be possible by some countries that they can carry out joint audits under the existing directive, the Directive on Administrative Cooperation. However, there are other countries who feel that, in fact, their national rules don't permit it. And their national rules may overrule and say, well, we can't do it. And what, from the Commission side, what we're doing is we're saying, well, we're interested because if there is a need for a new piece of legislation to permit or promote a joint audit, and if that would improve the internal market, then we from the Commission would be prepared to make a proposal. But we need to have the evidence base to be certain that it would be something that would improve the single market. At the moment, we're looking at it, and we're, if you like, in the gathering of information stage. And we also, when we're looking at this, of course, we look at it for direct tax, but we also look at it for excise duties and for VAT. And there are slightly different stages of development. At the moment, we believe that it's actually sometimes easier in direct tax. And one of the issues that we would have to consider is whether, if we came forward with an instrument, did we want to do one just for direct tax, or would we want to cover excise duties, VAT, other issues? But it's certainly, we're in at the stage now of saying it's something that we believe we might want to do, but we are in the hands, if you like, of the taxpayer and the other tax administrations to see whether or not it would be advantageous. I hope that answers your question.
Vielen Dank. Herr Käser möchte direkt.
Yeah, I'd like to support Mr. Gerlich in that remark, because if the Commission is moving towards a common corporate tax base, for me it's a no-brainer that there should be a joint audit, that there should be a common understanding and interpretation of those common rules. I don't know how close we are, or how many light years we are away from a common corporate tax base. Certainly we are light years away from a consolidated common corporate tax base, or triple CTB. But for me, it would be more a natural first step to say, folks, let's increase cooperation and exchange and working together in the European Union, in the common market. And then from that, we can build in the next step to come and achieve a common corporate tax base. For me, it would be a natural flow, which would make a lot of sense. And especially once we have it, we need joint audits, because otherwise we'll have an interpretation A in country A and interpretation B in country B, and then it might be called a common corporate tax base, but it will certainly in practice be not.
Vielen Dank. Herr Naumann?
Ja, die Frage der
The question of joint audits has been dealt with in connection with transfer pricing, and as a representative of the countries, I could observe how many reservations the country had in terms of joint audits. So I think there is considerable caution that is necessary and time to achieve that. That is the one side. And the willingness of the countries to actually open up to these types of possibilities. And for Germany, I can note, and it doesn't only apply to Germany, that in the procedures where we try to remove international double taxation, this is necessary. The case numbers are increasing, not only in Germany. And I have been dealing with transfer pricing for quite some time, and I ask myself, how should these procedures be solved, if not via a joint audit? Because we all know how long a mutual agreement procedure takes, not to speak of an arbitration procedure. That can take 4 or 5 years. And for the joint audits, and in our attempt with the Netherlands, we found that can be solved within 6 months or a year. Let me come back to the EU, what I found here as far as the member states are concerned, and I noticed that here as well. The problems involved in implementing that in practical terms are discussed endlessly, and another problem is added to another problem, and another precondition is added. But what is important is that these procedures just get going, because those who benefit most from it are the taxpayers, because it's a service provided by the tax authorities that they get together. And if they get together, they have a base, they will guarantee that there is not going to be double taxation. So all those involved should actually be interested in that. So my appeal in the interest of the taxpayers would be we should talk less about the difficulties and the problems, but we should actually carry out and implement these procedures, especially with countries such as China and India, where it's very difficult because they will learn when we do it. And then we will improve the double taxation burden for the taxpayer. I was in a meeting with VDMA, that is a machine builder in Germany. There were 20 companies around the table, and they all spoke about double taxation cases and contracts and so on. None of them said we will have a mutual agreement procedure because they all said it's going to take too long, too time-consuming, not possible. And in that situation, I think it is very practical and extremely necessary to get into joint audits, and it doesn't really matter on what procedural basis. If the precondition is that the purpose is to avoid double taxation. Thank you very much, Mr. Naumann.
Enthusiastic plaidoyer. I think there are three positions, and the one in the middle I haven't heard yet, and that's a question from me to the audience. There is from both Mrs. Schmidt the relevant and correct approach that we have also established between ourselves. In fact, what happens in a joint audit, it is only the facts that are being established, and from there on, each national law and each national tax authority proceeds. That's the legal formal position. Then there is the future, light years or I don't know how long, that there will be a joint audit with a binding outcome for both states in which there is a real negotiation already in place and within a legal framework. We don't have that, and we agree on that also. My question is, the one in the middle probably already exists, and that's also what Mr. Naumann refers to, I believe. If there is a joint audit with the formal position as it is, it might in practice lead to a situation where this is solved not only based on the facts, of course, but also with a joint interpretation and a joint explanation of the legal position. And my question is that the result that is already there in many cases?
Ja, Herr Naumann, direkt darauf nochmal vielleicht.
According to, in my opinion, in approximately 90% of the cases, if the two auditors agreed what the actual facts are, and that is relatively easy, if they can look at the effects from both sides, and they would get a much more comprehensive image than if somebody did it alone. So in 90% of the cases, I think a material agreement and the result that a double taxation is avoided for the taxpayer to be very probable. And then 90% of the cases would be solved within 1 year. There would be actually fantastic conditions for somebody who's ever participated in a mutual agreement procedure. And then I think it makes sense to say, yes, that is the direction we want to go in. Instead of always talking about how difficult it is, we have to look at the legal positions of the one or the other party. Quite honestly speaking, from a practical point of view, even though I work for the IRS, I am being practical here. What we're doing now is not viable long term. I would like to add something to that. Based on my experience of 20 joint audits or simultaneous audits, I can say that at the beginning, before any joint audit, I tell the taxpayer we are assuming that we're going to reach an agreement. Up until now, that hasn't happened, but maybe we won't agree at the end of the day. That hasn't happened yet. I always say that in advance. The first case where we don't agree as auditors still has to happen. And the 90% hurdle that Mr. Naumann just mentioned is something I would sign immediately. If I get together with my foreign colleagues, I can guarantee that more than 90% of the cases will be solved one way or another. If we know ourselves, if we knew that, because we know that we will create a lot of work for ourselves if we don't agree, and the company is happy. We don't want long litigation cases or court cases because they take just as long as a mutual agreement procedure. The mutual agreement procedures will come back to us, and then we have to inform the ministry again. So it's nonsense not to come to an agreement. And in practical life, that never happens. I would like to add to that and answer Mr. Koller. If you focus on the facts for transfer prices or profit distribution between various PEs, and if you agree on that, then the legal question will have been solved, and the fact would be binding. If the audit has been completed, the German auditor puts it into his audit report, and the auditor from abroad will do the same thing. And of course, they're going to reconcile and compare the two. So Mr. Naumann's 90% and the experiences of the Dutch participant bear witness to that. Of course, audits are always concerned with ascertaining facts. And sometimes you have discussions, but that is not the focal point. And if you really agree on the facts, you don't need a supranational regulation which says that this agreement on the facts is binding, because both automatically assume these facts. And if ever one can't agree, then there's nothing wrong. And we've got other procedures, and if necessary, one does do a mutual agreement procedure. But because that isn't used in practice, it means that if you have a joint audit, you always come to agreement because everybody is interested in having one. Also, the auditors are interested in closing the case as quickly as possible, as soon as possible. And we all know what we're talking about. In the really significant cases where big companies are audited, one always has several results. And one has to realize that these several results are realized as soon as possible, and the tax authorities want that, and the taxpayer want to know as quickly as possible how many taxes they will have to pay based on the audit. And they're not in any way interested in stringing it out over years and to have the Damocles sword of a double taxation hovering above them, where they might have to come to an agreement with a tax authority later. It's always very difficult if you don't come to an agreement. And for this agreement, you need a scenario, an arena, a forum, whatever you want to call it. And that would be the joint audit.
Eine letzte Frage.
Thank you so much. I can take one more last question. It's a comment. Kirsten Rösel, I work for the Federal Office for Taxes and have been coordinating since 1st of 2013. I also coordinate the international tax audits. As Lara Vandenhoff said before, I can fully confirm that, and also what Mr. Naumann said. And we're finishing our cases successfully by not having double the percentage, and so the 90% is even more. First of all, we meet with the tax auditors and clarify the facts, and the joint facts will be the basis for further talks in order to reach agreement and to avoid double taxation. And these are the ongoing procedures as being conducted at the moment, and taxpayers are mostly satisfied that there's a legal situation which does not have the character of a mutual agreement, but it's based on trust. It was made based on trust. That's what we do on the basis of the EU Arm's Length Administration Assistance and Mutual Assistance Act. We also can perform simultaneous. We don't use joint audits. We call it joint audits do not have a legal basis. That's a model of the OECD. That's why we call it gemeinsame Prüfung. But based on the EU Commission, so the rights of the taxpayers are quite different, because in Germany, taxpayers, when it comes to he has rights of consultation and information before, and Larry Vandenhoff mentioned it yesterday in the Netherlands, he doesn't have any such rights. And that's why this would be good if we could reach a common solution and a standardized solution. And I want to add to Mr. Schelling, and he's mentioned the Convention on Mutual Assistance on Tax Matters, and so can also have simultaneous tax audits can also be done with other countries as well, because the conventions are being adopted by many states, 200 states. There's also South Korea, Samoa, and many other states are listed where it would be possible practically, but actually from the federal government, we also have made no experience yet. But of course, we would be open-minded towards any such procedures. Thank you very much, Ms. Rösel, with review to the watch. We have 7.5 minutes until it will be 1 o'clock, and I promised that there will be a short final statement for panelists, and so Mr. Käser may say what he wanted to say anyway. But before that, please let me assess that during the discussion. First of all, I have to say that actually 1 and 45 minutes are not too long in order to discuss about this topic. I wasn't sure before. And we also established that joint audit process will speed up process. It always needs to be a win-win-win approach for the benefit of all parties involved, otherwise it won't work. And Mr. Käser told us that he would never give up his rights, and no one objected to that. So that means we need cooperational approach, and with this cooperational approach, that was the general consensus. So no one says 90% of the cases that would become, or would be rewarded back to refer to course, could be settled in an amicable manner. That is good success. Mr. Koller, let me ask you to make a final statement. If you met again in 10 years, how do we see joint audits? What will be our experience? My imagination is not enough for that. I learned over years that
I've learned that in tax matters, it is hard to predict anything that is longer than 1 or 2 years away. So I really have no idea. Will we have CCCTB? If yes, then we will have joint audits. We won't even be speaking of joint audits. We'll simply speak of audits, which will by definition be joint then. So I don't want to speculate, really. What I hear here is a good news show. And I wouldn't want to disturb this. I also heard a call towards the EU that we might need some harmonization in the taxpayer rights, in the participation of the taxpayer in the joint audits, and I think that would be helpful. But as long as the mentality is as it is here, for example, in a cooperation between the Netherlands and Germany, that seems to work fine. And as long as that is the case, what isn't broken needn't be mended. However, there may be other cases. And I come to the conclusion for myself that although the theoretical point is clear that the audit establishes the fact, it apparently helps that the tax authorities in both countries also agree on the interpretation. And I cannot other than believe then this is already part of the audit process. At least from what I know about Dutch audits, the auditor is already talking about a legal interpretation, and sometimes the distinction between establishing the facts and interpretation is a bit theoretical. From the facts automatically comes a matter of interpretation and of legal application of the law. But having said that, I am very happy with the outcome as it is, and if that is the outcome, it is indeed in the best interest of all parties involved, and as long as that is the case, it'll continue. We may need in future, if the number increases, the success percentage might come down, because also smaller companies might be audited, the number might increase, so maybe the success percentage will go down, in which case we will need some more regulation, I think. But until then, I would say let's continue and keep up the good work and keep up the good news.
Dankeschön. Tom Neale, wenn wir in 2026...
Tom Neale, if we would have a fully harmonized procedural law by 2026, what would you say?
Official, I have to say that there will definitely be a consolidated corporate tax base by then. If there were to be some disaster, and that were not the case, I think we will probably see more movements towards more joint audits. I suspect they may end up being wrapped up in more legal provisions, because I think otherwise you will find there will be a group of countries where you can run joint audits, but there will be some countries where you can't on soft law. So I think there might be pressure towards a more legalistic approach.
Dankeschön. Eugene Rossiter.
Eugene Rossiter. So in 10 years from now, you will have much less work because 90% of the cases will be done by joint audits.
I'll never have less work. That's simply not going to happen. In Canada, what I find is that most lawyers would rather fight than eat. And I think that the litigation will continue. It'll continue to ramp up. Right now, 90% of our cases are about 10% of the money, and 10% of our cases are about 90% of the money. And the 10% of the cases that are about 90% of our money take about 80% of our resources. And that's not going to change. The figures that we're talking about here are absolutely huge. I mean, they're larger than some budgets in the provinces and the states in Canada. And it's so significant that it's worth fighting over as far as I can see. But what I do see, a friend over here talked about the practical result, and I think as long as the auditors and the taxpayers are result-driven, you will get there eventually. I don't know when you'll get there, but you'll get there eventually sometime. But in the meantime, there's going to be a lot of turns in the roads and bumps in the roads. There's going to be a lot of jousting and pushing and shoving and screeching and roaring and people that are happy and people that aren't happy. But that's life. That's the way it is.
Vielen Dank, Christoph Schelling. Die Schweiz in...
Thank you very much, Christoph Schelling. Switzerland as a third-party state or European member state. What will be the outlook? Oh, that expands the question, actually. No, I can't say that. What I take from today's discussion, that important arguments of pragmatism and efficiency apply to and speak for this instrument, and seemingly there seems to be consensus here. I also can confirm that currently this is not going smoothly at the moment with a lot of countries. And that's why the state that I'm coming from is one of them, for the lack of institutionalized legal basis. Well, that has to be verified, and that's why you should have a clear view on that without any blinkers. And if that serves to help having less litigations and streamlining the structure, so hopefully we have progress in 10 years. Christian Käser.
The company will certainly become not a member state of the European Union, if that is the question. I absolutely believe that more than 90% of disputes within Europe are being resolved by joint audits, absolutely, but that's only a snapshot of the global situation. And the most urgent, most pressing cases are with non-European countries. And there I would be extremely hesitant to accept, without a given legal frame, any sort of joint audit or similar undertaking. We so far haven't even had a mutual agreement procedure with regard to China, so we have no experiences in that field, and we are certainly not diving into the adventure of having a full-blown joint audit with certain countries where we are not sure what the outcome will be. And I can see that you, Mr. Naumann, suggest that because there's no risk in for you. Because at the end, if they tax something which is pure fantasy, you can still walk away and do whatever you want, but we are the ones being double taxed. But honestly, last sentence, I love joint audits.
Good. Vielen Dank, das ist ein gutes Schlusswort.
That's a great final word. Thank you very much for the panelists. Thank you for having you and being up here, but also thanks for the audience for listening and making their contribution. Thank you. Thank you so much from our side.
We are very happy about the discussion and about the outcome. Thank you so much, gentlemen. Meine Damen und Herren, das Mittagessen steht.
Ladies and gentlemen, food is available for you. So I would like to say that this was a wonderful discussion as also was prepared in the business center by BMW. And the business center is available for you, and there would be seats for that, and the Otto Verlag, you can go there and enjoy lunch either down here or in the business center, and then come back for the last session of today. Thank you.